Good evening, everyone. Welcome again to another live streaming of Basic Transfer Pricing. We'd like to say thank you po. Thank you talaga sa support nyo. And we have reached the 1,000 subscribers. No? Thank you very much. Shout out, Tari.
Wala pa po, ma'am. Pero 5 viewers.
Okay. So shout out po sa ating 5 viewers, no? Our topic for tonight is the intercompany royalty, which is the dispute in the case we're going to discuss, and also the repatriation of cash dividend. Oh? So this is in the case of Analog Devices Inc. and Subsidiaries, which is the petitioner in this case versus the Commissioner of Internal Revenue. No? So, ano ba itong tinatawag na intercompany royalty? This is the royalty na ibabayad ng subsidiary sa kanyang parent company for the use of certain intangibles. And also, ano ba itong repatriation of cash dividend, no? Ito yung cash dividend ng subsidiaries na ni-remit niya doon sa parent company, no? Because of that, yung kanyang assets na 1.6 billion, magkano na lang natira? 400 million na lang. No? So, yun yung repatriation of cash dividend na nagkaroon ng issue. No? So, what is this case all about? This is the case of Analog Devices Inc. versus the Commissioner of Internal Revenue. This case was filed in 2016. No? So, 2016, 5 years ago. And then yung decision niya, okay, so 2016, yung decision, okay. So, what is this case all about, no? The background of the case. The parties stipulated in this case under Rule 122, yung rules of court ito, no? So the stipulated facts and facts drawn from the stipulated exhibits are incorporated hereby. So petitioner is a U.S. corporation with its principal place of business in Norwood, Massachusetts. Also, this is a company in the United States. Analog Devices Inc. is the petitioner, was founded in 1965, no? It is the common parent of a group of subsidiaries that joined the timely filing of consolidated federal income tax returns for the 2006 and 2007 tax years. It is also the parent of non-consolidated foreign affiliates. Parang sa Pilipinas din dito sa atin na yung group of companies, parent and subsidiaries, they're required to file a consolidated financial statements. So petitioner, which is the Analog Devices Inc., its subsidiaries and its affiliates design, develop, manufacture, and sell high-performance analog, mixed signal, and digital signal processing integrated circuits. No? So, integrated circuits ginagamit sa pag-manufacture ng mga equipments. Telecommunication. No? So, in 1976, petitioner incorporated Analog Devices BV, ADBV, which then built a fabrication facility of complementary metal oxide semiconductor technology. ADBV is organized under the laws of the Netherlands, with its principal place of management and business in Limerick, Ireland. For all relevant times, petitioner owned 100% of the issued and outstanding shares of ADBV, which was a CFC pursuant to Section 957. Ano yung CFC? Controlled Foreign Corporation ng Analog Devices Inc. No? So ano yung nagiging issue dito? The intercompany royalty. In 1982, kailan na founded itong si Analog noong 1965. So in 1982, in connection with the Section 482 adjustment, ano yung Section 482 adjustment? This is the section, the transfer pricing law in the U.S. under Section 482, which pag tinignan na natin in our previous lessons, this Section 482 is the same with Section 50 of our National Internal Revenue Code, which is the transfer pricing law also in the Philippines. Petitioner entered into a closing agreement with the Internal Revenue Service, parang compromise agreement, no? Appeals Office establishing an annual royalty from ADBV to petitioner equal to 2% of ADBV's net sales. Bakit magbabayad si ADBV ng 2% na royalty to analog devices? Bakit? Si analog devices ang may-ari, no, ng ADBV, no? So ADBV paid the 2% royalty to petitioner every year through the end of petitioner's 1994 taxable year. Hindi mo 1982, no? Hanggang 1994. At which time, petitioner and ADBV concluded that the royalty was no longer necessary. Pagdating na ng 1994, hindi na daw necessary yung royalty. So wala na royalty. So after the IRS had conducted an audit and determined to reinstate the royalty, pinabalik ng IRS, the Internal Revenue Service, yung royalty. Kasi hindi na nagde-declare ng income si analog from the royalty paid by ADBV. Kasi sabi ng analog, wala na daw, hindi na dapat magbayad ng royalty si ADBV, no? So, nung nag-audit ang IRS, pinabayad ulit ng 2% na royalty si ADBV to analog, no? Kasi lost income kay analog yun. So, lost collection din ng IRS, no? Okay. So, petitioner and ADBV entered into a cross-license agreement in 1998. So, pinabalik ng IRS. And then in 1998, nagkaroon na sila ng license agreement again, reflecting a 2% royalty from ADBV to petitioner effective November 3, 1986. Yung agreement, ginawa noong 1998, pero effective siya ng 1996, so retroactive. So by its terms, the 1998 license agreement was valid for 20 years. No? So valid siya for 20 years starting 1996. So kailan siya matatapos? 2016, no? The IRS regularly conducted examinations for petitioners' tax years following the 1998 license agreement. Yung license agreement na yan na retroactive ng 1996. So in 2006, the IRS conducted an examination for petitioners' 2001 to 2003 tax years. As a result of that examination, the IRS proposed under its authority pursuant to Section 482. So ano yan? Transfer pricing adjustment, no? Kasi Section 482. To increase the intercompany royalty to 6%, beginning with the 2000 tax years. So, hindi raw 2% lang yung royalty, dapat daw 6%. So, ano yan? Upward adjustment, no? Yung adjustment niya, tinaasan yung royalty. Petitioner's Chief Financial Officer agreed to the proposed increase for 2001 to 2003 by executing Form 4549. So, pumayag naman yung analog. So, petitioner filed an amended 2004 Federal Income Tax Return July 18, 2006 to reflect the increased royalty rate, no, from 2% to 6%. Petitioner timely filed its 2005 Federal Income Tax Return July 13, 2006 and reported a 6% royalty from ADBV. So 6% from 2% to 6%. For 2001 to 2005, the total increase in petitioner's royalty income due to the application of a 6% royalty as opposed to a 2% royalty was 429,175,634. Additional royalty amount. Kasi from 2% naging 6%. Based on the sales of ADBV yon. The transfer pricing adjustment giving rise to the additional royalty amount did not create indebtedness for federal income tax purposes, no? So, walang indebtedness. So, ibig sabihin, nagbayad yung analog. In July 2006, ADBV and petitioner credited and debited the respective intercompany accounts by the royalty adjustment amount. So, noong 2006, ayos sila na record, no? ADBB paid the additional royalty amount in a series of payments to petitioner between July 25 and October 26, 2006. Series of payments. So, siguro hulugan. Petitioner did not make an election under Revenue Proclamation 99-32 in 2006 with respect to payment. No? Petitioner repatriation and Section 965 election. So in 2005, petitioners and ADBB's Board of Directors approved a domestic reinvestment plan. No? Ano yun? To repatriate a cash dividend to take advantage of a limited 85% DRD. Yung DRD is dividend received deduction, no? Under Section 965. So petitioners' representative at this time were aware of guidance that the IRS had issued in the form of 3 IRS notices with respect to Section 965. ADBB declared the dividend and paid it to petitioner on October 24, 2005. So, decide yung board of directors na magkaroon sila ng cash dividend, no? Repatriate, parang magbabayad sila sa parent company nila ng cash dividend because of the DRD or the dividend received deductions na ino-offer din ng IRS, no? So petitioners' representative at this time were aware of guidance that IRS had issued in the form of 3 IRS notices with respect to Section 965. Ito yung notices, ito yung parang assessment, no, sa analog. ADBBs declared the dividend and paid it to petitioner on October 24, 2005. Kanino nagbayad si ADBB? Kay Analog. Si Analog, yun yung petitioner in this case. At the time of payment of the dividend, ADBB's cash balance, including marketable securities and short-term investment, was approximately 1.6 billion. No? Anong nangyari after? In cash balance at the end of the 2005 taxable year, yun yung nag-repatriation ng dividends. After it paid the dividend was 485,306,732 na lang. So, from 1.6, yung assets niya naging 485 na lang. So, ang laki nung binayad niyang dividend. Petitioner attached sa Form 8895, one-time dividend received deductions for certain cash dividend from controlled foreign corporations to its timely filed federal income tax return for 2005. On the Form 8895, petitioner claimed a Section 965 DRD or dividend received deductions of 879,629,844. So yun yung dividend na nire-repatriate niya from the 1.6 billion. No? Form 8895 requires the taxpayer claiming a Section 965 DRD to report the related party indebtedness of its CFCs as of the beginning and end of the testing period. Generally, an increase in the related parties' indebtedness of its CFCs during the testing period decreased the amount of the dividend. Siyempre, may utang ka. So, bawasan yung dividend. And there are other debtor pa nga na hindi sila nag-allowed na mag-declare ng dividend pag hindi pa bayad sa kanila, no? Yung loan sa kanila. Eligible for the DRD. Petitioner's testing period was between October 3, 2004 and October 29, 2005. Petitioner reported zero related party indebtedness for both the beginning and the end of the testing period. So noong 2005, wala siyang indebtedness, wala siyang utang. So the IRS examination for petitioners in year 2004 and 2005 taxable years, no? Under petitioner's Revenue Proclamation 99-32 election and the notice of deficiency. So the IRS commenced an examination of petitioners 2004 and 2005 taxable years in May 2006. So under investigation siya. The IRS commenced an examination for petitioners 2006 and 2007 taxable years around May 2006 and April 2007 respectively. On May 3, 2007, the IRS fax to petitioner an issue resolution agreement stating that ADDV's payments of the additional royalty amount resulted in a constructive dividend to petitioner. No? So, may constructive dividend to petitioner, yung pagbabayad niya ng royalty payment na 6%, no? Parang distribution of income, no? Yung royalty. So, in a letter to the IRS, pero tingnan nyo itong 6% na royalty, sino nag-adjust niyan? Upward adjustment din yan ng IRS. Ngayon, sila naman yung nag-notify sa taxpayer na they treat the increased royalty as constructive dividend. Pero sila din yung nagsabi noon na i-increase yung royalty to 6%, no? So, in a letter to the IRS dated July 17, 2007, petitioner's chief financial officer requested relief under Revenue Proclamation 99-32 Supra with respect to the additional royalty amount. No? Kasi agreement nila yun with the IRS, no? The election would permit petitioner to establish interest-bearing accounts receivable from ADBV instead of treating the transfer pricing adjustments as a constructive dividend to petitioner. So ano na naman ang gusto nila na treatment? Interest-bearing accounts receivable daw yung transfer pricing adjustment na dividend, yung ginawa nilang 6% instead of constructive dividend, no? So, nakakalito. Petitioner's treasurer, William Martin, also attached a statement pursuant to Revenue Procedure 99-32 to petitioner's timely filed 2006 tax return to ensure that the IRS would not treat ADVV's payment of the additional royalty amount as a dividend. Ang treatment nila is constructive dividend. So, parang distribution of profit, no? Kasi ang dividend is distribution of profit, kumita yung company mo. Samantalang ito, royalty payment to, so expenses to ng company. This is not coming from the retained earnings, but from expenses, no? So the statement reiterated petitioner's Revenue Proclamation 99-32 election and stated that petitioner was permitted to establish interest-bearing accounts receivable from ADBV. So in October 2007, during the course of the examination, anyway, itong interest-bearing accounts receivable, ito yung issue dito And for your information, this case was decided in favor of analog, no? So in October 2007, during the course of the examinations, the IRS raised Section 965B3 as an issue. On or around December 5, 2007, respondent issued a notice of proposed adjustment or NOPA, asserting that Revenue Proclamation 99-32 election resulted in an increase in related party indebtedness of 162,166,710. No? So yun ang findings ng IRS. So during petitioner's testing period, which required a reduction of the amount of the DRD, that petitioner had claim of 137,841,704. No? Yun yung dividend received deductions. Kasi nag-repatriate siya ng dividend sa analog. No? Kasi analog ang parent company ni ADBV. No? Remember that si Analog owns 100% of the shares of stocks ni ADBV. In May 2009, petitioner and the IRS signed a Form 906 closing agreement on final determination covering specific matters. Yung parang agreement, no? Meron din niyang ginagawa ang BAR, di ba? Yung agreement form. Pag natatapos na yung kaso mo. Excuse me. Okay. So, petitioner's chief financial officer signed the closing agreement on petitioner's behalf. He did not have signatory authority for ADBV, and no one with signatory authority for ADBV signed the agreement. So in this case, si ADBB, which is the subsidiary, which is yung ang nagbabayad ng royalty to Analog, did not sign the agreement. Sino lang ang nag-sign ng agreement dito? Si Analog lang. No? That's why ang verdict or yung decision dito sa case is hindi kasama dito sa ADBB. Why? Kasi hindi siya party to the agreement, hindi siya signatory to the agreement. No? So the parties' closing agreement is titled Closing Agreement on Final Determination covering specific matters. No? Sometimes, Revenue Proclamation 99-32, Closing Agreement. No? Yun yung pinirmahan naman nila nung nakaraan from the 2% royalty, increasing it to 6% royalty payment of ADBB to Analog. No? So the first section of the agreement includes the recitals, which are introductory, explanatory clauses beginning with the word various. No? Yun yung karamihan ng mga wordings agreement. No? Some recitals in the closing agreement are specifically negotiated, while other borrow standard terms from the IRS Revenue Proclamation 99-32. Pattern agreement. See Internal Revenue Manual. One of the specifically negotiated recital states, the parties desire to enter into this closing agreement to resolve with finality certain issues identified below that the IRS reviewed. Kaya nga agreement na to doon sa findings ng IRS. During CAP, ano yung CAP? Compliance Assurance Process. While impact, the taxpayer's tax year ended October 28, 2006. The recitals with standard terms address the primary adjustment under Section 482, the 6% royalty. No? So yun ang issue dito, no? Yung 6% royalty from 2% to 6%. Petitioner's Revenue Proclamation 99-32 election and respondent's decision that the provision of Revenue Proclamation 99-32 SOPRA should apply. So after the recitals is a caption that states, now it is hereby determined and agreed, no, for all federal income tax purposes that, so yan ang wordings ng agreement. This is a standard wording from the IRS Revenue Proclamation 99-32, pattern agreement. Okay. So the caption emphasizes the transition from the recitals to matters upon which the parties have agreed. The determined clauses, those to which the parties agreed to be bound, follow the caption and include both standard and specifically negotiated terms. One of the determined clauses establishes 5 accounts receivable, no, between petitioner and ADBB, reflecting the difference between the 2% and 6% royalty rates for 2000 and 2005. No? Bakit? Kailan ba nangyari yung agreement? No? Each account was deemed to have been created as of the last day of petitioner's taxable year to which it relates. No? So, yung cover dito na dates are 2001 to 2005. So the determined clause establishing the accounts receivable states, taxpayer has established intercompany accounts receivable set forth below, which were recorded on taxpayers' books and treated as term loans to controlled entity. Sino yun? Si ADBB. Parang utang pa ni ADBB yung payment niya na 6% na royalty, no? Reflecting the following balances, each such account receivable being deemed to have been created as of the last day of the taxable year to which it relates. This deemed accounts receivable did not come into existence until the execution of the closing agreement. Bakit deemed accounts receivable lang siya? Treated lang siya as accounts receivable when hindi talaga siya accounts receivable. No? So other determined clauses discuss inter alia payment of the accounts receivable, the tax implications of the payments, and the calculation of interest on the accounts. The closing agreement does not mention Section 965B3, and we infer from this that the parties did not reach an agreement with respect to Section 965B3 in the closing agreements. So, kasi sa closing agreements, hindi naman kasama yung ADBB. This resulted to the transactions between ADBB and Analog. No? So the IRS subsequently issued a notice of discrepancy, no? Dated April 19, 2012, determining that the accounts receivable established under Revenue Proclamation 99-32 SUPRA constituted an increase in related party indebtedness during petitioner's testing period under Section 965B3. The IRS therefore determined to decrease the amount of the 2005 dividend eligible for the Section 965 DRD. Actually, ang gusto nilang bawasan dito is the dividend received deductions, no, under Section 965. So respondent would not have determined that Section 965B3 applies to the accounts receivable absent petitioners, Revenue Proclamation 99-32, election, and the closing agreement. Petitioner timely filed a petition in this court for redetermination, no? Yung redetermination ng accounts receivable, no? So discussion, applicable law and IRS guidance. So Section 965. Section 965 was enacted in October 2004 by the American Jobs Creation Act of 2004. So it was subsequently amended by the Gulf Opportunity Zone Act of 2005. Okay, so Section 965A provides that a corporation that is a U.S. shareholder of a CFC may elect a one-time 85% DRD or dividend received deductions for eligible cash dividends received from the CFC, no, yung controlled foreign company. Generally, a taxpayer makes Section 965 election by filing a Form 8895 with its timely filed federal income tax return for the year. Although Section 965 imposes several limitations on the availability and the amount of the DRD, ito yung dividend received deductions, no? This case concerns only the limitations provided by Section 965B3. Section 965B3 reduces the amount of the eligible dividends by any increase in the amount of indebtedness. So yun ang kine-question nila dito. Pagka may indebtedness si CFC, bawas yan doon sa eligible dividend, no? To any related party during the testing period, related party indebtedness. The testing period is generally the period between October 3, 2004 and the close of taxable year for which the taxpayer makes the election. So the commissioner has carved out an exception to the related party indebtedness rule for intercompany trade payables. Indebtedness arising in the ordinary course of business from sales, leases, licenses, or the rendition of the services that a related person provides to or for a CFC is not related party indebtedness. Under Section 965B3, provided that the indebtedness is actually paid within 183 days. No? Okay. So, indebtedness kasi accounts receivable yung dispute dito, no? Secondary adjustment under Section 482. Section 482 authorizes the Secretary to adjust the items of entities owned or controlled by the same interest. When the Secretary makes an allocation under Section 482, the adjustment of the controlled taxpayer income is known as the primary allocation. Kasi ano sabi nung Section 482, the Secretary may allocate, distribute, no, or a portion, income or deductions. The regulation requires corresponding adjustments with respect to the income of members of the group that were affected by the primary allocation. These corresponding adjustments are known as correlative allocations. No? For example, if a primary allocation increases a U.S. parent corporation's income, the correlative allocation will decrease the income of its CFC by the same amount. Kasi ano yan the transactions of the other will affect the other, no? Kaya nga sila tawag sa kanila is correlative. Okay. Because the primary and correlative allocation shift taxable income from one related party to the other. Now, the entities must make so-called secondary or confirming adjustment. No? to reconcile the entities. No? So ito yung sa adjustment natin, meron tayong tinatawag na primary adjustment, secondary adjustment, and also this conforming adjustment. To reconcile the entities' cash accounts with their adjusted tax positions. The regulations under Section 482 provide two methods of making the secondary adjustment. No? So, anong sabi ng Section 482 when you make an adjustment? Whereas here, a U.S. parent corporation's income has been increased and its CFC income has been decreased as a result of a transfer pricing adjustment. The method include treating the allocated amount as deemed dividend from the CFC to the U.S. parent, or, in appropriate cases, pursuant to such applicable revenue procedures as may be provided by the Commissioner. Repayment of the allocated amount without further income tax consequences. So the Commissioner promulgated Revenue Proclamation 1932, supra pursuant to the above quoted regulations. Revenue Proclamation 1932 supra permits qualifying U.S. taxpayers to make secondary adjustment by establishing an interest-bearing accounts receivable from or payable to its CFC or controlled foreign corporation in the amount of the primary transfer pricing adjustment in lieu of treating the adjustment as a deemed dividend or a capital contribution. So yun yung nangyari doon sa repatriation of cash dividend, no? Anong treatment doon? Treating the adjustment as a deemed dividend or capital contribution. So for cases pending before the IRS, a taxpayer may elect treatment under Revenue Proclamation 99-32 by requesting the election in writing signed by a person with authority to sign the U.S. taxpayer's federal income tax returns and submitting the request before closing action is taken on the primary adjustment. If the taxpayer qualifies, the IRS and the U.S. taxpayer will enter into a closing agreement under Section 7121 of the Code. No? So, nagkakaroon sila ng closing agreement. Section 4.01 describes the features of an account established under these procedures. The account may be established and paid without the federal income tax consequences of the secondary adjustments that would otherwise result from the primary adjustment. The account is deemed to have been created as of the last day of the taxable year for which the primary adjustment was made. It bears interest computed pursuant to Section 1.482-2 Income Tax Regulations from the day after the deemed establishment date. For purposes of Section 482 Income Tax Regulations dealing with the safe haven interest rates, the account shall be considered to be a loan or advance having a term extending from the day after the date the account is deemed to have been created through the expiration of 90 days after execution of the closing agreement on behalf of the Commissioner. Revenue Proclamation 99-32, Section 4.03 clarifies the electing treatment under the revenue procedure does not affect the primary adjustment but affects the taxpayer taxable income and credits to the extent indicated in Revenue Proclamation 90-32. Revenue Proclamation 99-32, Section 4.03 further states that the election eliminates the collateral effect of secondary adjustments such as those described in Section 2, no, regarding deemed dividend treatment. Okay. So ano yung guidance daw ng IRS on the intersection of Section 965 and Revenue Proclamation 99-12? No? So yun na yung mga batas na inano nila dito na cite or na jurisprudence, no? Yun yung mga decided case or opinion na kinuha nila. Okay? So, IRS guidance on the intersection of Section 965 and Revenue Proclamation 99-32. And they quoted the decision of the court in BMC Software Inc. versus Commissioner. Ano naman yung nangyari dito sa BMC Software Inc. versus Commissioner. Actually, if you try to read the case further, meron silang tinatawag dito na yung doctrine of study diseases. Why? Kasi uh, may mga previous decision na yung cases na parang ganito din yung circumstances or yung circumstances, no? So, yung BMC Software Inc. versus Commissioner, no? So, ano nangyari dito sa BMC Software? We first addressed the intersection of Section 965 and Revenue Proclamation 9932. So, ano daw sila yung parang nag-overlap, no? Kasi may intersection. So, closing agreements in BMC Software Inc. versus Commissioner BMC Software. BMC Software Inc., a U.S. corporation, had claimed a Section 965 DRD for its 2006 taxable year. Unrelated to the DRE, BMC had paid royalties to its CFC for 2002 and 2006 with respect to software that the entities have collaboratively developed. No? So in 2007, BMC and the Commissioner entered into a transfer pricing closing agreement for 2003 to 2006, reflecting the Commissioner's determination that the royalty amount should be reduced to reflect arm's length pricing. No? So also in 2007, BMC and the Commissioner entered into a closing agreement under Revenue Proclamation 99-32. To conform the entity's cash accounts with the primary adjustments. Okay, so Revenue Proclamation 99-32, closing agreement created two accounts receivable from CFC to BMC for federal income tax purposes, which were deemed established as of the close of BMC's 2005 and 2006 taxable years. The CFC paid the accounts receivable in full within 90 days of the closing agreement. The Commissioner subsequently issued BMC a notice of discrepancy for 2006, determining that the accounts receivable constituted a retroactive increase in related party indebtedness under Section 965B3 that reduced BMC's claim section. So, our holding in BMC's software. Okay, so we began our analysis in BMC software with Section 965. After determining that Section 965B3 does not include an intent requirement, we refer to dictionary definitions of the word indebtedness and concluded that for purposes of Section 965B3, indebtedness means the condition of owing money or being indebted. No? So, BMC Software 1. We next determined that an account receivable established under Revenue Proclamation 99-32, SOPRA, meets the definition of indebtedness because an account receivable is defined as in account reflecting a balance owed by the debtor. No? So, CID 230, 233, no? Quoting Black's Law Dictionary 18th edition, 2004. So, we then analyzed the effect of the parties, no? Revenue Proclamation 99-32, closing agreement on our analysis of Section 965B3. Section 8 at 234, relying on sharing Court versus Commissioner 69 TC 579, 1968 case. We stated that Revenue Proclamation 99-32, SOPRA, does not preclude all collateral federal income tax consequences. No? We held that the Revenue Proclamation 99-32 closing agreement relieved the taxpayer of the consequences that would have resulted absent the election, but that the accounts receivable are deemed established for all federal tax purposes. No? Because the closing agreement provided that the accounts receivable were deemed to have been established during BMC's Section 965B3 testing period, we held that the accounts receivable qualified as retroactive increase in related party indebtedness during the testing period. We therefore sustained the Commissioner's determination. Okay. So, ano yun? Yun yung previous, no? Doon sa issue na yan. So, the U.S. Court appeal for the Fifth Circuit holding in BMC Software 2, no? Sa Software 2, ito naman yung nangyari, no? It was an appeal decision to the U.S. Court of Appeals, no? Okay. So, the Court of Appeal stated that the fact that the accounts receivable backdated does nothing to alter the reality that they did not exist during the testing period because the accounts were secondary adjustment to correct cash account imbalances and not correction of a prior year's account. So, ito din yung sinasabi ko palagi na iba yung prior year prior period adjustment kaysa correction ng taxes. Current talaga, actual talaga yun sa taxes. The Court of Appeals then considered whether the parties contractually agreed in Revenue Proclamation 99-32 closing agreement to treat the accounts receivable as related party indebtedness despite the plain language of Section 965, no? Noting that the closing agreement did not mention Section 965, the Court of Appeals concluded that the standard closing agreement phrase for federal income tax purposes did not expand the scope of contract to include Section 965. So, yun ang opinion ng court. So, hindi siya kasama talaga yung closing agreement na i-treat mo na accounts receivable yung secondary adjustment, no? So otherwise, the Court of Appeals reasoned the provisions in the closing agreement regarding foreign tax credits and the tax implications of interest payment would be surplusage, no? Surplusage na lang siya, parang di kailangan, panggulo lang. Additionally, the Court of Appeal applied the canon expressionis est exclusio alterius. So, kung ano yung included, excluded na yung iba, no? Which means that the specificity and apparent comprehensiveness of an agreement, enumeration of a category of thing, here, tax implications implies the things not enumerated are excluded. So kung hindi yun nakasama dyan, hindi talaga yun nakasama, excluded siya. So because the closing agreement listed several tax implications with specificity, but did not mention others, such as Section 965, the court held that the closing agreement excluded those consequences which it failed to enumerate. And ano yun? Yung treatment ng accounts receivable. Ni ADBV, no? Yung subsidiary ng analog. The Court of Appeals distinguished sharing. The court stated that sharing involved, ito yung mga jurisprudence na cases, no, na ginagamit nilang reference in the resolution of this case. So, stated that sharing involved a collateral tax consequences that flowed from an action that the taxpayer had taken on the basis of a closing agreement. The payment of accounts receivable established under the predecessor of Revenue Proclamation 99-32. However, the issue in BMC Software, Inc. was the tax consequences of the establishment of the accounts receivable themselves, not any action that BMC had taken as a result of the closing agreement. No? Absent a stipulation to the contrary, this case is appealable to the U.S. Court of Appeals for the First Circuit. No? Okay. Given the reversal and parties' argument, the instant case requires us to revisit our analysis in BMC Software 1. So, na-study natin yung BMC Software 2, here, BMC Software 1. No? At ano yung sinasabi nila dito about stare decisis. No? Stare decisis, ito yung, once na may decision na yung court, lift and touch mo na yun, at kung ano man yung case na same circumstances with the case already decided, then leave the decision of that court undisturbed. So, anong dapat mong gawin? Yung previous decision, yun din yung i-apply mo on the present case, no? So the doctrine of stare decisis is important to this court, and we are mindful of its role in this case, no? So the important doctrine of stare decisis the means by which we ensure that the law will not merely change erratically, it will develop in a principled and intelligible fashion. But of course, hindi naman definite or final na yung stare decisis na since meron ng verdict yung court previously, ganun din ang i-apply mo ngayon. Of course, for those who have a different facts and circumstances, pwede namang mag-iba yung decision, no? Unjustified yung court to do it. While stare decisis is not an inexorable command, the careful observer will discern that any detours from the straight path of stare decisis in our past have occurred for articulable reasons and only when the court has felt obliged to bring its opinions into agreement with experience and with facts newly ascertained. So you have to ascertain the facts para may reason ka rin na yung previous decision pala nyo, hindi applicable to the case. Our history does not impose any rigid formula to constrain the court in the disposition of cases. Rather, its lesson is that every successful proponent of overruling precedent has borne the heavy burden of persuading the court that changes in society or in the law dictate that the values served by stare decisis yield in favor of a greater objective. So, hindi naman porket meron doon tayong doctrine of stare decisis, hindi na tayo pwedeng gumawa ng ibang desisyon, no? Pagka justified ka naman at may ibang factors, then you can abandon the previous decision. This case presents issues on which a court of appeals has reversed our prior decision. In such a scenario, clearly, we must thoroughly consider the problem in the light of the reasoning of the reversing appellate court, and if we convince thereby, the obvious procedure is to follow the higher court. Kung mapapansin ninyo, meron ding issue on stare decisis dun sa previous case na discuss natin nung Monday, no? Yung physical presence, no? Ng company na yung Wayfair, no? Versus South Dakota, wherein ni-require nila yung physical presence in order to collect the sales tax. Eh, wala na yung physical presence na requirement because of the digitized economy. So, bago na yung realities, no? So, in that case, nagkaroon, it was also cited yung stare decisis, but in that case, justified yung court not to follow the previous decision of the court, no? Because nag-iba na yung economic realities so that mag-iiba na rin yung circumstances, no? Okay. May viewers pa tayo?
Meron, ma'am. May shoutout po, ma'am.
O sige, shoutout muna.
Shoutout po, ma'am, kay Sir Eugene Cruz.
Kuhain nyo ng cake natin, ah.
Tapos kay Sir Ryan.
Okay.
Pades. Good evening daw po, ma'am.
Okay po, good evening.
Good evening din daw po, ma'am. Sabi ni Ma'am Jonalyn Bonlang.
Okay, good
Ito po
evening.
kay Ma'am LV Galanido. Good evening
Oh, si Ma'am LV. Thank you. Thank you very much, Ma'am LV.
Shoutout din po kay Sir Christian Brian Kakayan.
Oh, atin siyang participants, di ba?
Apo, ma'am.
Yes.
Pati kay Ma'am Bernadette Lonon.
Oh,
Good
yes.
evening daw po.
Good evening po.
Sila pa lang, ma'am.
Okay. Anyway, ito yung mga decisions, opinions ng court, no? Pero doon sa decision na talaga ng court, this case is in favor of analog, no? Kasi mayroon ang silang agreement with the IRS, Internal Revenue Service, pero hindi yun binding with the ADDV kasi doon sa agreement hindi pumirma yung ADDV or yung subsidiary, no? So in this case, na-question nila yung previous jurisprudence in BMC Software 1. So dito sa decision, ito yung decision in BMC Software 1 which has been abandoned kasi yung issue nila sa stare decisis, iba yung facts and circumstances dito sa Analog Device Inc. versus Commissioner of Internal Revenue, no? Okay. Sige, anong sabi nila dito? The application of studied diseases was particularly apropos because there were numerous and consistent court opinions interpreting and or applying the previous holding. So to our knowledge, no other court of appeals has spoken on the issues we consider today. Therefore, the important goals of studied diseases to ensure the even-handed, predictable, and consistent development of legal principles and to foster reliance on judicial decisions, no, are not served by our continued adherence to our previous opinion. So, hindi na rin fair yung decision nila if yung court nakatali dun sa kanilang previous decision. Kasi of course, yung mga bagong cases, iba naman ang facts and circumstances niyan. Just like sa mga cases natin in transfer pricing, di ba? It is factual, no? So, it is decided based on the facts and circumstances of the case. There has been no predictable or consistent development of the legal principles affecting this case, no? So, stating that starry diseases which arose from a necessity to preserve the harmony and stability of the law. Yun naman yung reason na pagka-decided na yung isang case at ito na yung decision ng court, leave it untouched. Huwag mo nang pakialaman. I-apply mo na lang sa mga upcoming na cases na same facts and circumstances of the case. Yun. Pero kung mag-iba na yung facts and circumstances, of course, hindi mo na siya i-apply. May reason na rin yung court not to apply. No? So, starry diseases which arose from a necessity to preserve the harmony and stability of the law requires adherence by courts to a principle of law or settled by a series of decisions. No? Series of decisions ng court. No? Na nagde-decide sila on the same facts and circumstances. So, dapat irespeto din yan daw ng ibang korte, no? So, a prior task court opinion when a court of appeals had reversed our earlier opinion and we had examined the issue only once before. So, the court had decided in early stages of its section 6320, 6330 jurisprudence. Generally, starry diseases is of particular importance in cases involving contract rights because reliance interests are involved. And cases involving statutory construction because of the possibility of legislative intervention. No? Yung involving statutory construction, yung construction ng law. No? Although contract rights are at issue here, we find it unlikely that the commissioner would rely to the detriment of our opinion in BMC Software 1 by deciding to leave a Section 965 provision out of future Revenue Proclamation 99-32. Actually, ito yung dalawang legal basis nila na nagko-contradict, no? Ito yung 965 at saka yung 99-32 na closing agreement, no? Kasi nag-agree na yung taxpayer dito meron na silang agreement in writing. Especially given the advice memorandum on BMC's appeal. We also find the possibility of congressional action on this issue to be low because the Section 965 election has expired, no? On balance, we conclude that the importance of reaching the right result in this case outweighs the importance of following our precedent. Yung precedent, yun yung mga previous decision. That's why na-question dito yung starry diseases, no? So, most matter it is more important that the applicable rule of law be settled than that it be settled right, no? So, we therefore conclude that the starry diseases does not prevent us from reconsidering BMC Software 1 and we do so below, no? Okay. Closing agreement. Ito yung closing agreement nila na pinirmahan ng executive ng analog devices and also the Internal Revenue Service. No? So the Secretary is authorized to enter into closing agreement with taxpayers pursuant to Section 7121A. Although certain closing agreements settle the taxpayers' total tax liability for a particular period, a Form 906 closing agreement, which is the type at issue here, is used to settle specific matters affecting tax liability. Closing agreement is final and conclusive. Yes, no? Final and conclusive siya. But if you try to look at the last portion ng decision, ang sabi doon, hindi siya binding kay ADDB kasi si ADDB did not sign the agreement, no? And it is binding on the parties as to the matters agreed upon, no? Binding siya as to the parties, which is si analog devices lang. Pero si ADDB, hindi, no? So under Section 7121, a court may not include as part of the agreement matters other than the matters specifically agreed upon, no? So kung ano lang yung agreed upon, yun lang, hindi mo na ma-bind yung hindi kasama doon, no? Which in that case, hindi kasama doon sa ADDB. No? So mentioned in the closing agreement. The scope of a closing agreement is therefore strictly construed to encompass only the issues enumerated in the closing agreement itself. Siyempre, kung ano yung agreement, yun lang kasama doon. So any recitals in a closing agreement are not binding on the parties. However, recitals are explanatory and can give insight into the intent of the parties. It is important to distinguish between matters which are merely informative and explanatory and matters which are being agreed upon. Kaya nga, ako palagi ko yan na reminders with lawyers, no, that when you craft or make an agreement or contract, be very particular or be very specific with the tax, no? Sino ba yung dapat mong bayad ng tax? Kasi if silent, sino palagi ang magbabayad? Yung taxpayer sa sale, sa contract of sale, sino magbabayad? The seller, no? Pero kung may agreement na buyer, then it is the buyer who will pay. At ano yun? Paano i-compute naman ng BIR yun? Pagka ang seller hindi magbabayad ng tax, but it is the buyer who will pay the tax. Ina-add on ng examiner yung payment of taxes to the price or consideration, no? So yun naman ang mangyayari. Okay. So which are very merely informative and explanatory and matters which are being agreed upon. No? So the former should be segregated from the latter and should ordinarily be reflected in the introductory recitals contained in the various clauses. Kasi yung mga agreement natin, may mga various clauses yan eh. Various, no? Parang justification yan kung bakit nagkaroon ng agreement. Closing agreements are contracts and they are subject to the rules of federal common law contract interpretations. Kasi ang source ng civil law natin, which is nandoon yung obligations and contract, is common law, no? Contracts are construed according to the intent of the parties as of the time of entering into the agreement, no? Intent is inferred from the four corners of the agreement where the contract is unambiguous. Extrinsic evidence may be used to discern intent where the contract has ambiguities. Sometimes when the contract has ambiguities, it cannot be enforced, no? As if there is no contract. The starting point for ascertaining the parties' intent is the contract itself, no? Kaya, alam nyo, pagka may kontrata, yan na yung dadalhin mo sa korte and that is the cause of action na eh, no? Yan naman gagaling. The contract must be read as a whole and the contract must be interpreted in context. In context, kung ano yung laman niya, huwag ka nang mag-interpret, no? Kaya nga ako sa cases, hindi ako nag-interpret, no? Kung ano lang yung laman ng case, yun na i-explain mo. Kasi unang-una, tapos na itong case na to. This has been decided by the court. Bakit ka gagawa ng sarili mong opinion? So this is because the meaning of words commonly depends on their context. When the parties have adopted a writing as a final expression of their agreement, interpretation is directed to the meaning of the writing in the light of the circumstances. Kung ano yung nakasulat dyan, no? So, analysis of petitioner's revenue proclamation 99-32 closing agreement, no? So, the four corners of the agreement. Ito na yung agreement na yung sabi nga dito, hindi binding kay ADDB kasi hindi naman pumirma sa ADDB. No? So in BMC Software 1, we held that the closing agreement that established similar accounts receivable for federal income tax purposes created related party indebtedness under Section 965B3. We acknowledge that in this case, the closing agreement states that the accounts receivable were established and the petitioner treated them as term loans for all federal income tax purposes. However, in BMC Software, we did not consider the context in which the parties used the captions, which the rules of federal common law contract interpretation require us to do. So we therefore interpret the closing agreement by giving proper weight to the section 7121 jurisprudence and the closing agreement as a whole. No? So ano yung decision dito ng judge? Doon na tayo sa decision, no? Kasi na-elaborate na natin yung facts and circumstances of the case. Okay? Conclusion, no? Ito na yung conclusion ng court. We hold that accounts receivable did not constitute indebtedness under Section 965B3, no? Kasi ang treatment nila doon sa agreements nila, accounts receivable, no? So petitioner is therefore entitled to the entire amount of its claim DRD under subsection A, no? Yung decision ng BMC Software is overruled. So yung question nila na stare decisis na yung previous decision of the court should be adopted by the court in making a decision, overruled na, hindi na sinunod, no? So, the entire amount of its claim DRD or yung dividend reduction, received deductions, allowed na i-claim nila, no? Magkano yun? Saan ba nanggaling yung disputes? Yun yung repatriation of cash dividend ng ADDV na binayad niya kay analog devices, no? And then nag-claim siya ng dividend received deduction. Sino yung nag-claim? Si analog na dinidisallow ng IRS, no? But in this case, panalo si analog, no? So we have considered the parties' remaining arguments as to the extent not discussed above conclude those agreements are irrelevant, moot, or without merit, no? So the case is in favor of the petitioner na si analog. Okay? So maganda tong mga cases sa transfer pricing, no? If you want to improve your knowledge in transfer pricing, try to read the cases in its entirety, ha, hindi yung ano lang, summary lang, no? Yung digest lang ng case. Kasi pag digest, hindi mo alam kung ano nangyayari. And yung mga doctrine along the way, hindi mo yun makikita. That's why long case talaga ang ano mo, gabasahin mo in its entirety. Makabasa ka lang ng isang case with isang doctrine or isang issues, ang laking bagay na, no? Kasi ma-apply mo na agad and you already have the idea. So, may shoutout pa, Hari?
Wala na.
Okay, so, mayroon pa po tayong bukas, no? 10 o'clock to 12 o'clock. Yan naman yung transfer pricing and the digitized economy. No? So, I would like to say thank you and have a good night.